Thank you so much. Well, thank you so much for the introduction, and thank you for the great honor and opportunity to be here. A very special thank you to Michael Maas for the generous speaking invitation, to Glenn Bailey for the outstanding travel and technical assistance, and to the partner organizations for this conference for their support, including the Gambling and Addictions Research Center, the Problem Gambling Foundation of New Zealand, and of course, Maori Public Health. My topic today is legal protections for individuals with problem gambling, and what I would like to do is simply walk you through 5 illustrative areas of law in the United States, and just as a descriptive matter, show you whether or not individuals with problem gambling have legal benefits, protections, and rights under these laws. As background, you heard during the introduction that I work at the University of Nevada, Las Vegas, which is the university located just a few blocks from the famous Las Vegas Strip. And my law school, its first specialty law program was a gaming law program. I am not a part of that program. And as you can imagine, that program is designed to, it looks like, whoops, the screen went out right here. Okay, that program was designed to train our law students to provide legal counsel to casinos and other members of the gambling industry. Again, I am not part of that program. I actually direct our new health law program, and from that perspective, I train our law students to be able to represent individuals who, because of their physical and mental health conditions, might need access to legal protections and benefits and rights. So I bring a health law and bioethics and medical humanities perspective to this topic, but not a gaming law perspective and not a provider perspective. Now, the 5 areas that I'm going to go through include health insurance law number 1, disability discrimination law number 2, disability benefit eligibility law number 3, administrative law, including professional licensure number 4, and criminal law number 5. And what I'm going to show you is that currently in the United States, individuals with problem gambling do have some protections, benefits, and rights in the 1st, 3rd, and 5th areas. But as of today, individuals with problem gambling actually have no legal protections or benefits or rights under the 2nd area, disability discrimination law. And in some jurisdictions, they have few or less rights in the 4th area. Now, these are just illustrative areas of the law. You actually heard during our welcome so many other ways that problem gambling can intersect with the law. For example, individuals with problem gambling can run up against family law issues. If you have 2 partners who are divorcing and a court is making a decision about how and whether to divide community property, including financial assets, some courts in the United States give less community property or less money to the problem gambler compared to the other individual. Child custody cases, child support cases, they all come out differently depending on whether one of the parties does or does not have problem gambling. In my time today, I'm just going to talk about the 5 areas that you see up here, but we're actually currently working on a casebook that would go through every single area of the law in the US where there is an intersection between problem gambling and the law. One last thing before I go ahead and begin. I attended each and every session yesterday, and they were all fantastic, and I learned so much. I wanted to bring up an issue that was brought up in 2 different sessions yesterday. Our 2nd keynote speaker had an outstanding slide where he mentioned all the D words: disorder, disability, disease. I am going to use some of those D words only because in the United States they are legally defined terms, and in order to get protections or benefits or rights under the laws that you see up here, you do need to meet the definition of having a disorder, a disability, or a disease. I am very aware as a patient's rights advocate, as a bioethicist, and as a medical humanist, I am very aware of the suggestions and connotations and problems with these words. So maybe during the Q&A or afterwards, we can talk about changing the language that we use in the United States. Without further ado, let me actually just walk you through these 5 areas and one more time show you whether or not individuals in the US have legal protections in these areas. Number 1 is health insurance coverage. It'll take me a bit to get here, but the short answer is that in my state, in Nevada, starting in 2017, individuals will have mandatory access to treatments, health insurance coverage of treatments and services for gambling disorder, but not until 2017. In other states, you need to do analysis, and I'm going to show you how that analysis works. As background, in the United States, we don't have national health care. We have a very patchwork system of health insurance coverage where many individuals like me have private health insurance as a benefit of our employment, and then we also have both public health care programs such as the Medicare program that provides health insurance to individuals who are over the age of 65, as well as Medicaid, which is a joint federal and state program that each state implements that provides health insurance coverage to individuals who have low income and low resources. We have a patchwork health insurance system in the United States. Traditionally, both our public health care programs, including Medicare and Medicaid, as well as our private health plans, expressly discriminated against individuals with any type of mental health condition in general and with problem gambling in particular. Just to give you a few examples of ways in which both our public health care programs and private health plans discriminate against certain individuals with mental health conditions compared to physical health conditions. Many of our private health plans, and I'm going to give you 3 examples of these in a moment, simply do not provide any health insurance coverage for any treatments or services or counseling for individuals with problem gambling, even though they freely and willingly and voluntarily provide health insurance coverage of other physical health conditions, for example, cancer, asthma, arthritis, pregnancy, as well as perhaps other mental health conditions such as maybe major depression, bipolar disorder, and schizophrenia. In the US, even when we have a private health plan that voluntarily provides health insurance coverage of treatments and services for problem gambling, they tend to impose, or historically they tended to impose, this is all changing literally as I speak, historically they tended to impose a number of what we call limiting features. For example, they would allow lower coverage over a person's lifetime for their mental health conditions. They would allow lower coverage over on an annual basis for spending for that mental health condition. They would only allow a lower number of covered inpatient hospital days, lower numbers of covered outpatient visits to psychiatrists, psychologists, social workers, and counselors. Many health plans would impose higher deductibles, higher co-payments, and higher co-insurance amounts on individuals with mental health conditions. And many health plans would impose more stringent medical necessity requirements as broader experimental and investigative exclusions. Long story short, in the US, we have a terrific history, meaning very bad history of what we call mental health insurance benefit disparities against individuals with mental health conditions compared to physical health conditions. Now, just to give you 3 examples of this so you can see what I'm talking about, I just pulled these off the internet, but this is a health plan out of the South Dakota market, and what you can't see here is that they pretty much cover or provide insurance for every single physical health condition and most mental health conditions that you can think of. But as you can see right in the middle of the slide, for some reason they don't feel like providing insurance coverage for treatments and services for problem gambling. This is another illustrative, not exhaustive example of a student health plan that is affiliated with an aeronautical university in Florida. And as you can't see, what you can't see here is that they provide health insurance coverage for almost every physical health condition under the sun, as well as many mental health conditions. But of course, if you are addicted to gambling, you are simply out of luck. This is actually one of my former clients, the University of Pittsburgh Medical Center, located in Pittsburgh, Pennsylvania. This is the health plan for their employees, including their doctors and their nurses and everyone else who works here. What you can't see is that they provide insurance coverage for almost every single physical health condition and many mental health conditions, but of course they exclude addictive gambling. So I would say that individuals with problem gambling historically have been expressly discriminated against, and these are legal phrases, expressly discriminated against in these private health plans, which are contracts. And our Medicare and Medicaid programs, which are governed by statutory and regulatory law, did the same thing. So before I move on to federal legislation that is improving this, let me just say, a lot of people say, well, how is this allowed? Why was this allowed historically? And the reason it's allowed is that many states have mental health parity laws, which require individuals with mental health conditions to be treated equally compared to individuals with physical health conditions. However, most state laws expressly exclude individuals with addiction to gambling from these mental health parity protections. So if I go back one more time, these are contracts that I'm showing you. Contract law is expressly discriminating against individuals with problem gambling. And now this is actually a state statute that, in my mind, expressly discriminates against individuals with problem gambling, meaning the language of the statute itself says if you're lucky enough to have major depression, you're good. If you're unlucky enough to have problem gambling, you're simply out of luck. So my colleagues and I, who are health law folks and mental health law folks and mental health parity advocates in the US, we've been working for over 20 years to remedy this. It is our belief that all individuals with all physical and mental health conditions, regardless of whether it's pregnancy or cancer or major depression or bipolar disorder or problem gambling or alcohol addiction or drug addiction, we feel that all individuals should be treated equally. So we've been lobbying the federal government for what we call true mental health parity for 20 years. And we had our first success exactly 20 years ago in 1996. President Clinton signed into law a piece of legislation called the Federal Mental Health Parity Act of 1996. And this law was very, very limited, but basically what it did is say, look, if you're a large group health plan, and I belong to a large group health plan, meaning the University of Nevada, Las Vegas has a large number of employees, and it provides health insurance to all of us. So my health plan, this statute basically said, look, large health plan, if you offer mental health benefits, then you cannot discriminate in the context of lifetime spending limits and annual spending limits for patients or for employees who have mental health conditions compared to physical health conditions. But unfortunately, that's all this law did. It was so limited. First of all, it was not a mandated benefit law. This law expressly said that no large group health plan actually has to provide health insurance benefits for any particular mental health condition, such as problem gambling. So to avoid having to comply with this law, what many large group health plans did is simply not offer mental health benefits in general, or not offer benefits for individuals with alcohol use disorder or a drug use disorder or gambling disorder, and that was perfectly allowed. In addition, get this, 20 years ago, the only way to get this through Congress is that, and this was a compromise, they expressly excluded from protection from this law individuals with substance-related and addictive disorders. So 20 years ago, this law, it was designed to help people with mental health conditions, but the way it was ultimately enacted or passed is it only helped you if you had a non-substance-related or non-addictive condition, say major depression, bipolar disorder, or schizophrenia, you would benefit. But if you had drug addiction, alcohol addiction, or gambling addiction, you would not benefit. Third, it only regulated parity in what we call lifetime and annual spending limits, so it didn't do anything else to the higher deductibles, the higher co-pays, or anything like that. And finally, it only regulated large group health plans. There are a million other ways to get health insurance in the US, including through small health plans, individual health plans, Medicare, Medicaid, et cetera. It only regulated or gave benefits to people like me who happen to be lucky enough to work for a large employer with lots of employees. So that was 1996. There were many limitations to that law. So now fast forward 12 years to 2008. President George W. Bush is in office, and near the end of his term, he signed into law another piece of legislation called the Paul Wellstone and Pete Domenici Mental Health Parity and Addiction Equity Act. And I remember the morning the statute was signed into law, we opened it up, and when I saw that phrase addiction in the title, I knew we were going to make some headway. What this law said is that large group health plans that offer mental health benefits shall not discriminate against individuals with mental health conditions with respect to financial requirements, so they couldn't impose higher deductibles, higher co-pays, and higher co-insurance amounts on individuals with mental health conditions compared to physical health conditions. And they also couldn't impose lower or worse or less good treatment limitations. So they couldn't give individuals with mental health conditions fewer inpatient hospital days or fewer outpatient visits. This law was an incredible improvement on President Clinton's law for two reasons. First of all, there was no express exclusion for individuals with substance-related and addicted disorders. So finally, individuals who are addicted to things that you inhale, inject, or ingest, or other addictions could be protected by this law. In addition, it extended parity to these other things, including deductibles, co-pays, and co-insurance amounts. The problem with this law, though, it was still not what we would call a mandated benefit or a mandated offer law. Nothing in this law said a health plan has to offer mental health benefits. All it said is that if you choose to voluntarily offer mental health benefits, you shall make them equal to the offered physical health benefits. So what a lot of lawyers who advise health plans to do is simply not offer mental health benefits in general, or not offer gambling disorder benefits in particular, and if you didn't offer them, you didn't have to make them equal to the offered physical health benefits. In addition, this statute only applied to large group health plans, and again, millions of Americans have health insurance through a small group health plan because they're employed by a small employer. Many Americans, millions of Americans purchase health insurance on what we call the individual health insurance market. Millions of Americans are covered by Medicare, Medicaid, et cetera. This was a very limited law. That said, we are still grateful to both President Clinton and President George W. Bush for the work that they did. So that was 2008. Now let's fast forward 2 years to March 23, 2010. Third administration here, President Obama, and on March 23, 2010, so almost 6 years ago, President Obama signed into law the Patient Protection and Affordable Care Act, which is PPACA. And then 7 days later, on March 30, 2010, he signed into law the Healthcare and Education Reconciliation Act, known as HISERA. PPACA, March 23, as reconciled by HISERA, is what lawyers in the US call the Affordable Care Act, or the ACA, but the popular media calls Obamacare. And this is very significant. What Obamacare, or the ACA, did is this. It is called an Essential Health Benefits Provision, or an EHB provision. It doesn't apply to all health plans, but it does regulate those prior non-regulated small and individual group health plans. And it says when you offer a health insurance policy to a member of the public, you have to include 10 sets of essential health insurance benefits. And the one that I'm interested in is the fifth one down, or letter E, which is mental health and substance use disorder services, including behavioral health treatments. Now, this is a problem with federal health law. Note how vague that statement is. First of all, note that it doesn't say which particular mental health conditions. For example, it doesn't say major depression, yes, or gambling disorder, no. Note that it uses the phrase substance use disorders, but doesn't mention behavioral addictions or process addictions. And note that it doesn't mention particular procedures or treatments or services, for example, cognitive behavioral therapy or individual or group or family counseling. All it says is that certain health plans in the United States have to offer mental health and substance use disorder benefits. But for those of us who are problem gambling parity advocates, we got excited here because we felt this was a way for us to put our foot in the door and to require health insurance companies to offer problem gambling treatments and services. So the way this was ultimately implemented, and this always happens in the US, the federal government gets a great idea, but then they can't figure out how to implement it. So then they kick it to the states. So I live in Las Vegas, Nevada, and I'm going to use my state as an example here, but this analysis needs to be done in every state. The federal government told each state to pick a health plan that existed on March 30, 2012, and that's a magic legal date. And that health plan is what we call the benchmark or the reference plan in that state. And once a state picks a benchmark plan from its 2012 plans, that plan sets the minimum scope of treatments and procedures and services that must be covered under that plan. So my state, Nevada, selected this plan right here. And what this means is that for years 2014, 2 years ago, 2015 last year, and this year, 2016, what is covered by this health plan is an essential health benefit in my state, and Nevada residents get insurance coverage for these treatments and services and procedures. But what is not in this plan is not an essential health benefit, and these individuals can still be discriminated against. So just to show you how this works for this year in my state, these things up here are included in this plan. So if you look at the bottom, substance abuse disorder, including inpatient and outpatient services for alcohol use disorder, drug use disorder, et cetera, are included. So right now in 2016 in my state, if you're an individual who's addicted to drugs or alcohol and you belong to a regulated health plan, you have mandatory health insurance coverage for drug and alcohol addiction, both inpatient and outpatient services. Now get this, my benchmark plan, as of the magic legal date, which is 2012, contained this exclusion. It excluded the impulse control disorders. And my benchmark plan at this time in 2012 referenced the current edition of the DSM. And in 2012, the current edition of the DSM was the DSM-4, not the DSM-5. And in the DSM-4, the phrase pathological gambling was included as an impulse control disorder, which means that in my state we have more gambling than in any other state in the United States, more than New Jersey, more than Louisiana, more than Iowa, and more than Missouri. This means that treatments and services for pathological gambling are not mandatory or essential health benefits compared to other treatments and services. However, this only applies through the end of this year. Now, there are many, many problems with the DSM, and our second keynote speaker yesterday did an amazing job of identifying some of them. As you can see here, in May of 2013, the American Psychiatric Association renamed the condition from pathological gambling to gambling disorder, and of course reclassified it from an impulse control disorder to a substance-related and addictive disorders. So what this means now is that each state was required to select a new benchmark plan that would go into effect for years 2017. So for example, my state, Nevada, selected this benchmark plan that you see right here. And these are things that are included in this benchmark plan for 2017 going forward. And what you see here is that it does include inpatient and outpatient services for substance addictions. But if you look at the top of the slide, any other mental or behavioral health condition. Now, there are exclusions, and the impulse control disorders are still excluded. But this benchmark plan, and the magic legal date for this plan was 2014, references the current addition to the DSM, which means that in my state, in 2017 going forward, problem gambling treatments and services are no longer excluded under the impulse control disorder exclusion because they're not impulse control disorders. It's actually a substance-related and addictive disorder by the language of the contract. So to summarize, things like this, and one more time, this was actually just an example from the University of Pittsburgh Medical Center. Things like this, though, meaning exclusions, contract exclusions like this, will be illegal in my state in 2017 going forward. That's just my state. You'd have to do this whole benchmark plan analysis in any other state, but that's how it works. So just to summarize very quickly, I've gone through health insurance coverage of problem gambling in the US. The answer is that the federal government requires the provision of essential health benefits. You have to look at each state's benchmark plan to figure out what is an essential health benefit. And in my state, starting in 2017, but not yet, problem gambling treatments and services will be an essential health benefit. So this is one area where legal protections are moving perhaps in the right direction. I have 4 other topics to go through, and I can go through them very quickly in about 4 minutes each so we can still finish on time by 10:20. Let me go through 4 other areas of the law. The second is disability discrimination law. In the United States, we have very robust protections at both the federal and the state level for individuals with physical and mental disabilities. This started in 1990 at the federal level when President George Bush, the first President Bush, signed into law the Americans with Disabilities Act of 1990 called the ADA. And what this statute does is provide protection from discrimination in 3 contexts. Employment, meaning an employer can't not hire you or can't fire you or can't demote you because of a disability. State and local government, meaning, for example, say your state or local government provides social services to people who have physical and mental disabilities. They can't discriminate against you and not give you meals or shelter because of your disability. And then finally, public accommodations, which basically means private businesses, like a doctor's office or a dentist's office, can't not see you because you have HIV compared to someone who doesn't have HIV. Now, in order to get protection from discrimination under the statute, you have to fall within the definition of an individual who has a disability. And the definition is right up here. It's a physical or mental impairment that substantially limits a major life activity. And major life activities include things like thinking, concentrating, and working. So many attorneys have made an argument that individuals with problem gambling have a mental impairment that substantially limits the major life activities of thinking, concentrating, and working. And for those of you who saw the outstanding screening of that movie last night, you can see exactly what I'm talking about. However, get this, when the statute was signed into law, our Congress just thought that individuals with what they called compulsive gambling weren't worthy of protection. So I'm going to show you in a second, but if you're lucky enough to have major depression, bipolar disorder, schizophrenia, if you're lucky enough to be recovering from addiction to alcohol, and if you're lucky enough to be recovering from addiction to drugs, you are protected under the statute, and your employers and state and local governments and private businesses can't discriminate against you. But if you gamble, you are not protected under the statute. Okay? So there are many, many cases where problem gamblers who were outstanding at their jobs and could perform all of the essential functions of their jobs and really excelled at work, their employers would fire them or not promote them or would demote them because the employers maybe had some type of personal or religious opposition to gambling, and these individuals would sue for disability discrimination. And every single time, and this is just one illustrative case that you can see right here, the courts will say, I'm sorry, my hands are tied. Congress and the Americans with Disabilities Act expressly excluded compulsive gambling from protection under disability law. Now, the ADA was passed in 1990. 18 years later, in 2008, President George W. Bush signed into law the ADA Amendments Act of 2008. Now, this statute's only 8 years old. So I remember when this statute came out, these amendments, many of us were hopeful that some of the exclusions in here would be eliminated. But when we open this statute up, it does the same thing, meaning there are exclusions from the definition of disability for compulsive gambling. And in fact, in case law that we have interpreting this statute, as well as regulations that you can see right here, again, basically what our governments are saying is that major depression, bipolar disorder, PTSD, OCD, schizophrenia, all of those things we think substantially limit brain function. But at the end of the day, we just do not think that individuals with gambling are, in a sense, good enough to meet the definition of an individual with disability. And so we see this in cases, this is a very recent case, it's only 6 years old, where again, an individual who could perform all of the essential functions of his job, was a very good employee, he gambled after work, his employer didn't promote him, and he sued, arguing disability discrimination, and unfortunately he lost. Okay, so that's the second area, and in my remaining 15 or 10, let's see, in my remaining 16 minutes, let me just quickly go through the other 3 areas. The third area is disability benefit eligibility. Now, this is an interesting area of the law, and I did a lot of this in my practice. In the United States, disability benefit law can be one of 2 types. In the US, we have something called Social Security Disability Insurance, or SSDI. Picture yourself if you're riding a bike and maybe you are hit by a car and you suffer a traumatic brain injury and you literally lose all of your cognitive abilities. You can no longer work. What SSDI will do is give you a monthly cash benefit so that your loved ones can still care for you and provide you with shelter and food and clothing because you now have this traumatic brain injury and can't work. So that's called SSDI benefits. In addition, any individual in the United States can purchase on the open market, and many individuals like myself are very lucky to receive as a benefit of employment private, short, and long-term disability insurance benefits. For example, my husband is a heavy road cyclist. He rides not dozens, but sometimes hundreds of miles on the weekend, and we have a lot of impaired drivers in Las Vegas, and I see in the newspaper every single day stories about cyclists being hit by cars and then suffering traumatic brain injuries and not being able to work. And we have purchased extra short and long-term private disability insurance benefits in case that ever happens to him. I will have an income replacement every month, a check from our private disability insurer. So the million-dollar question here is, can individuals with problem gambling either get public SSDI benefits from our federal government, or can they get private, short, and or long-term disability benefits from a private disability income insurer? And this is an interesting one. The federal government does not specifically exclude individuals with problem gambling from SSDI benefits, meaning there's no statute or regulation or case, just like in the last section where there was under disability discrimination law saying you have problem gambling, unfortunately you can't get benefits. However, the practical answer here is that most individuals with problem gambling who apply for public SSDI benefits or who say they would like private, short, or long-term disability benefits under a private health insurance plan, they're denied for one of 2 reasons. Unlike disability discrimination law in Section 2, when we're talking about disability benefit law here, there's not just one question about whether you get benefits. Do you have a disability? If you have a disability, there's a second question, which is, can you do your prior job? So my husband's an IT guy. Can he still do his IT work with a traumatic brain injury? Or can you do any other work in the national economy? So for example, if I was in an industrial accident and my hands were cut off and I sewed for a living, I might not be able to sew anymore. But if I could do telephone marketing with a headset that didn't require my hands, I wouldn't be able to get disability income benefits because I could do another job in the national economy. And what happens, and this is just a random case I selected out of Minnesota, when individuals with problem gambling apply for SSDI benefits or private disability benefits, the courts always say, well, if you're healthy enough to go to a casino to gamble, then you're healthy enough to go to the casino and work as a janitor or a plumber or something like that. So their response is that always, I have never found a case that says otherwise, their response is always that these individuals can perform other work in the national economy. The other limiting feature, and this frequently comes up in private insurance plans, is this. If the reason you lose your job is because you have a traumatic brain injury due to cycling on a Saturday or Sunday, the court will say, yes, you are disabled because of your disability, and that's a circular thing. But if the reason you lose your job is because you commit a crime, the courts will not give you benefits here. So I used to represent a lot of physicians and nurses and attorneys who were addicted to alcohol and drugs, and if the reason they lost their job is because they committed a crime in the US, like DWI, then the courts will say, you didn't lose your income because of your disability, you lost your job because you committed a crime. So that's the other way these cases come out. So one more time, just to summarize here under number 3, individuals with problem gambling are not expressly excluded from legal protections in the US in terms of disability benefits. However, because courts think they can do other work in the national economy, or because some individuals lose their jobs because they've committed a crime, that's how they end up not getting disability benefits. Okay. The fourth area I wanted to talk about is professional discipline. Again, as background, I'm a former healthcare attorney, and I used to represent a lot of what we call in the US impaired healthcare professionals, so physicians, psychologists, nurses, social workers who themselves have either physical or mental health conditions that interfere with their work. And this is actually an area of the law called administrative law, meaning my opposing counsel is not a plaintiff's lawyer representing an injured patient, but my opposing counsel is like the state medical board or the state nursing board or the state bar that's trying to take away the license to practice medicine, license to practice nursing, license to practice law of a physician, a nurse, or an attorney. And so the million-dollar question that comes up here is if you're a professional and you have some type of license in the US, again, a license to practice medicine, a license to practice architecture, a license to practice nursing, social work, psychology, counseling, or a license to practice law, if you do a behavior that is not allowed by your state board, a state medical board, a state nursing board, et cetera, and they take away your license, is there any chance that you can get it back? Or do these administrative agencies discriminate against individuals with problem gambling? Now, the good news is that I could not find one state law in any state in the United States that says something like this. If you're a physician or if you're an attorney and you committed an illegal act associated with your problem gambling, you can never get your license back. So there are not express exclusions in administrative law like there are in disability discrimination law. The only catch or the only problem here, and here we can actually talk about language, but when you read all of these opinions where all of these doctors and nurses and social workers and psychologists and attorneys and architects have lost their licenses, many times because they, in cases involving attorneys like this one right here, attorneys usually misappropriate client trust funds to finance their gambling, so that's how attorneys will lose their license to practice law. What we see when we go through the opinions is what I consider maybe a medical misunderstanding of problem gambling at best, or actually sometimes what I think is stigmatizing language. For example, this is a case that involves a very good friend of mine. His name is Doug Crawford, and he's an outstanding family lawyer and criminal lawyer in Las Vegas, and I have lunch with him on a regular basis. He is brilliant. He is outstanding. When he was in the throes of his addiction, he misappropriated almost $400,000 of client trust funds. He went into 6 weeks of intensive inpatient therapy. Then he did over 8 to 9 years of outpatient counseling, and he has been to thousands of GA meetings. He fought so hard to get his license to practice law back, and this past June 2015, after like 8 or 9 years, he finally got his license to practice law back, and now he is paying restitution, and he is will over in 2 years' time probably make complete restitution to all of his former clients. When you read cases like this, though, they always use phrases like character weakness. So this is the court saying he has a character weakness. This is another opinion basically saying he is a terrible and despicable person, or he has sunk to terrible and despicable depths. Here is another opinion in the same case saying that if we gave him his license to practice law back, he would be a black stain on the bar. And I would just say that I do not condone illegal behavior, but I do not think that individuals who have inappropriate social behavior or commit crimes due to some type of physical or mental health condition are black stains, are terrible and despicable, or have character flaws or weaknesses. In my mind, they have physical or mental health conditions that need to be treated. So I object to much of the language that you see in these administrative law opinions. One other thing that I want to mention just very quickly is that Many states, whether you go into the Medical Practice Acts, the Nursing Practice Acts, the Social Work Practice Acts, the Architecture Practice Acts, or the Law License Practice Acts, they use language like remove or cure, and you can see them right here. And basically what they're saying is that if an individual who engaged in the inappropriate behavior or committed a crime that is associated with his or her physical or mental health condition can prove to a court that their condition has been removed or their condition has been cured, then the court will give them their license back. And so what many times happens in these cases is that very well-intended mental health professionals who have been treating these individuals will testify that they have been doing tremendously in treatment, that they are currently in recovery. They'll use words like sustained remission from illegal behavior or from their addictions. One more time, they'll use words like treatment, recovery, and remission, which are common addiction words. And the court will actually use that language against the individual with a problem gambling because they'll say, no, we only heard remission, recovery, and treatment. We did not hear removal, like the way penicillin removes a bacterial infection. We did not hear the word cure. And since the doctor or the psychologist or the counselor didn't say you're cured, then we will not give you your license back. So one thing that we're doing is we're working with administrative agencies that issue licenses to get rid of the removal and cure language and to insert treatment, recovery, rehabilitation, and remission language. One other thing that I wanted to mention is that many state courts and state laws relating to license reinstatement, again, whether it's for a mental health professional, a physical health professional, an architect, or an attorney, they have special provisions like this if you are lucky enough to be addicted to alcohol or drugs. They'll basically say this: the attorney can be reinstated as long as he or she has pursued rehabilitative treatment, they've abstained from the use of alcohol or drugs for at least a year, and then a mental health professional testifies that the individual is likely to continue to abstain from alcohol or drugs in the future. We actually love this language because this allows us as attorneys representing the impaired healthcare provider or the impaired attorney to argue that they should be able to get their license back once they satisfy this criteria. The only problem is that note that only alcohol and drugs are mentioned here. There is no other type of behavioral or process addiction that is mentioned here. So frequently when I represent any type of individual who has lost his or her license due to conduct associated with problem gambling, the court will not allow me to show these three elements to argue that the individual should get his or her license back because they'll say this only relates to drug and alcohol, it doesn't relate to gambling. Okay. In my last 5 minutes, let me just quickly talk about criminal law. I put this last because this is the thing that everyone always asks me about. As a health law person, in a way, I think it's the least interesting, but this is the question I get asked all the time, which is in the US, if an individual is a problem gambler and he or she commits a crime associated with problem gambling. So for example, yesterday in the movie screening, we saw several cases of individuals who took money from their loved ones in order to finance their gambling. Is there any other option? Meaning, is there any protection from criminal sentencing? And the answer is you have to look at your state law. I live in Nevada, and here is a piece of Nevada legislation that we've had in place since 2009. And it does provide some options that divert an individual away from criminal sentencing and towards treatment. So this is what my state statute says. And note that they use the language problem gambler. So before I was talking about disabilities, before that I was talking about gambling disorder, now I'm going to use the phrase problem gambling. But what this legislation says is that if you are a problem gambler and you've been convicted of a crime, like check kiting or something like that, and you committed the crime in furtherance or as a result of your problem gambling, there is a possibility that you can request and be diverted away from criminal sentencing and diverted into a program for treatment for problem gambling. Now, depending on how you look at this, some people like the statute and some people don't. Note that there are a number of exclusions on the bottom of the slide. So if you've committed certain crimes, for example, domestic violence, certain sexual offenses, certain crimes against a child, certain other crimes, you're not eligible. But on the other hand, if you've done things like low-level theft, check kiting, et cetera, these are crimes that are eligible. Now, if you're eligible, what happens is that if you ask for it, and you can ask for this hearing, you can actually get a hearing before a judge, and what you have to do is provide evidence showing that you're a problem gambler, that you committed the crime that you just got convicted of in furtherance of your problem gambling, that treatment or rehabilitation would be good for you, and that a mental health professional thinks that you'll do well in recovery or remission. And if you can prove that, what ends up happening is they will divert you away from sentencing. They will not sentence you. They will not send you to jail. And instead, they'll send you to treatment, either inpatient treatment and or outpatient treatment for 1 to 3 years. Now, there are several requirements that you have to comply with. They must find a problem gambling treatment center. And where I live in Las Vegas, there are actually several very, very good ones. The court can say things like, before you'll have to pay restitution to your clients. The court will require you to be under the supervision of a qualified mental health professional for no less than 1 year, but up to 3 years. The court will also say that you might be, in a sense, committed to inpatient treatment, or if the mental health professional thinks you can do it on an outpatient basis, that's fine as well. And I already mentioned the restitution. These are the qualified mental health professionals in Nevada that can supervise an individual who's a problem gambling in a problem gambling treatment program. And then finally, if you meet these requirements, your conviction will be set aside. And here is the magic language from my state statute. The person's sentencing must be deferred, and the person's conviction must be set aside if the qualified mental health professional, after that 1 to 2 to 3 year period, basically certifies to the court that the person has been successfully treated for problem gambling and a number of other requirements. Okay, so thank you so much. I think I ended on time. One more time, 5 areas of law where individuals sometimes do and sometimes don't have legal protections, benefits, and rights. Yeah.
Thank you so much. Not only am I impressed with your presentation, I'm also impressed with your time, Stacey. We have a couple of minutes left for questions. Stacey, would you like to take one question? Stacey. Stacey. Oh.
Yeah.
I don't agree with the statement I'm about to make, but I'd be fascinated to hear your response as a lawyer, because I'm an insurance academic. Many insurance companies and reinsurance companies argue that one of the reasons that they put forward for not including mental health is that diagnosis is particularly spongy, subjective, open to abuse. Uniquely, there's always abuse and there's always subjectivity. That's actually, there are some striking things showing up in the actuarial data, so that insurance companies are very concerned now about expanding it. Now, I don't agree with those premises, but I'm fascinated to hear your response from a legal perspective.
So I used to work at Vincent Elkins, which was a law firm that had a health industries group, and most of my colleagues actually represented health insurers. I was on the patient and provider side, but what my colleagues would argue against that is that there are actually many physical health conditions that don't have certain diagnoses, and the ones they would use most frequently would be things like lower back pain. And many individuals with lower back pain can get health insurance coverage for their condition, although there are not great objective ways of measuring exactly how much back pain a person is in and whether they should get an implant or whether they should just get drugs or go to physical therapy or go to yoga or something like that. So I would just say there are other physical health conditions where we don't have, crystal clear X-ray diagnostic abilities. Yes.
And as a follow-up question, presumably you've also encountered, coming from insurance industry lobbyists and others, you've also encountered the nexus of arguments around moral hazard, right?
Yeah.
Could you comment on how, what is the state of play with respect to those arguments in law?
Yep, so in the United States, we used to have, before the Affordable Care Act, so before March 23, 2010, we used to have a system where health insurers could either not cover you or could charge you more based on pre-existing conditions, et cetera. And so, long story short, we had many problems associated with adverse selection, moral hazard, et cetera. As a result of the Affordable Care Act, no insurance company in the United States that is regulated under the Affordable Care Act can discriminate against any individual in terms of whether or not to cover and in terms of how much to cover, other than family size, geography, smoking, and there's one other thing that I'm missing. Gambling or substance-related disorders is not one of them. So our problems relating to adverse selection and moral hazard have gone away. One important line in my research that I didn't mention today, just because it would take too much time, is that we have a lot of studies in the United States that show that both mental health parity, including for the substance and process and behavioral addictions, as well as mandatory mental health and substance use disorder benefits, in the short term, it increases outpatient mental health visits But in the short term and in the long term, it decreases emergency room visits, and it lowers the overall cost of total, and when I say total, I mean physical and mental health care. So we've successfully used that line of studies to argue to health insurers that if you cover this, one more time, it'll drive up in the short term outpatient mental health visits, it drives down in the long term emergency room visits, and then total physical health care costs, as well as inpatient mental health care costs, and it is cheaper.